A very good evening, gentlemen. I believe we all had quite a great day. All right, you're welcome to tonight's online class. I still remain your host, O.O. Stevens. And today we are going to be looking at the topic summary judgment procedure under civil litigation. We're looking at the topic summary judgment procedure under civil litigation. And most often than not, this topic is discussed alongside default judgment. So we are going to be getting to know what is summary judgment and what is also default judgment. And we're going to see the peculiarities that are between them, and we'll also see when the application for each of them is to be made. But first of all, we are going to be taking summary judgment. Summary judgment is a judgment given in favor of the claimant summarily without going through a full trial. When we say that a judgment is given summarily, that means that there was no time that there was a calling of witnesses, there was no time that there was any adducing of evidence, there was no time that anybody entered into the witness stand and he was actually sworn in or affirmed to give evidence. So summary judgment application for it is made at the beginning of filing of your originating process by way of writ of summons. And summary judgments are usually given where the claimant has established that the defendant has no good defense to the action. This is an exam area. Law school may ask you, what does the claimant have to establish before the court can grant summary judgment to him? He has to establish that the claimant has no good defense. Please, there is a difference between having no good defense and having no defense. So when the court considers that the claimant has no good defense and all the necessary formalities has actually been observed, the court may give judgment on the merits of that particular matter. And when the court gives such a judgment, the judgment will be said to be on merit. The implication is that the court that gave that judgment cannot set it aside. The implication is that the court that gave that judgment cannot set it aside. Thus, it is only going to be set aside on appeal. Now, for the purpose of law school discourse, for the purpose of your bar finals, there are monumentally only two types of summary judgment. For the purpose of this discourse and for the purpose of bar finals, there are monumentally two types of summary judgment. Please, there are still others, but due to our law school learning and our own confinement, for the purpose of the discourse, we only have two types of summary judgment. We have summary judgment under Order 13 of Lagos Rule. It used to be summary judgment under Order 11, but because of the new Lagos Rule, it is summary judgment under Order 13 of Lagos Rules, and also have summary judgment under the undefended list procedure pursuant to Order 35 of Abuja Rules. We have the summary judgment under the undefended list procedure pursuant to Order 35 of the Abuja High Court Rules. And we are going to be taking these two types of summary judgments individually to look at the peculiarities that are inherent in them and to also look at the procedure that are obtainable in them. Now let us take the first one, summary judgment under Order 13 of Lagos High Court Rules. The scope of summary judgment under this rule is that it is available in all claims and all actions, including declaratory actions, provided that the plaintiff believes that the defendant has no good defense to his claim. When we say that an action is declaratory means the court, please just declare my right. The court is not asking anybody to do anything. There is no obligation. So there are types of judgment. There are judgment known as declaratory judgment. There is a judgment known as executory judgment, and there is also a judgment known as interlocutory judgment. Let me briefly explain this before I go further. When we say that summary judgment under Order 13 of the Lagos Rules also applies in declaratory action. Declaratory action means I am bringing this action to court for the court to just declare that this is the person that has the right to do this. The court is not asking anybody to do something. The court is just making a declaration. But when it is executory judgment or executory action means that when the court gives its judgment, it means that one person has an obligation to do a thing. while interlocutory judgment are judgment given during the pendency of the substantive suit. So we now said now that summary judgment under the Order 13 of Lagos Rules is available in all types of claims, all types of claims. If you're making a claim for title to land, if you're making a claim with respect to landlord and tenant, if you're making a claim with respect to being owed, if you're making a claim with respect to money, any type of claim, you can bring it under the summary judgment under Order 13 Lagos Rule procedure. And what we are saying now is that provided that you believe that the claimant has no good defense to his claim. You could see in Bafana's question, law school will give you a scenario and they will ask you if the claimant wishes for this particular action to be dispensed with quickly. Advise him on the procedure or the mode he would employ. The answer to that question is always he will employ the summary judgment procedure. Now, it may not end there. The next thing that may come will now be the documents that the claimant has to file along with the application for summary judgment. The document that the claimant has to file along with the application for summary judgment. Please, we are still treating summary judgment under Order 13 of the Lagos Rules. And the documents that would accompany application for summary judgment under Order 13 are 1. Writ of summons. 2. Statement of claim. 3. List of documents to be relied on. 4. Witnesses' statement on oath. And 5. Affidavit and written address in support of that application. These are the documents that are going to accompany this particular type of summons. Please, I would want you to note the difference between these documents we just mentioned now and the documents we are going to mention when we get to the undefended list procedure. It is different. Now, when an application for summary judgment has been made, it is always by way of motion on notice. And this application shall be made at the court registry. This application shall be made and shall be filed at the court registry. And upon that, the registrar shall now cause the defendant to be served. The registrar shall now cause the defendant to be served with these particular processes so that the defendant can now choose to defend or not. Now, where the defendant wishes to defend, he shall take the following steps. 1. He shall file his statement of defense. 2. He shall file his depositions of witnesses, that is witness statement on oath. 3. He shall file his list of witnesses, that's the list of documents that he wishes to rely on. He can also file a counter affidavit. But remember that counter affidavit is not necessary when the application is on point of law. When you are really countering on point of law, you don't need to file a counter affidavit. Also, he shall file a written brief in reply to the application for the summary judgment. And where he has not entered any appearance earlier, he shall file a memorandum of appearance. Now, when he has actually filed his own documents and the judge or the court goes through these documents and the court notices or discovers that this man does not have a good defense, summary judgment shall be given in favor of the claimant. But where the court sees that the defendant has a good defense, the court shall now go ahead and the matter will be entered in the general cause list of the court and it shall be set down for hearing. Please, having a good defense is different from proving your case. The court only sees that he has something that looks like a good defense. Okay, let us give him the opportunity to come and establish his case. That does not mean that he has proved his case. No. When he has filed his statement of defense and the court looks at the documents, everything, and the court believes that this man seems to have a good defense, then the matter shall be set down for hearing. Remember, we told you that the only ground for which summary judgment shall be given is when the claimant has been able to show that the defendant has no good defense. Now, I want you to note the following points. Where the defendant filed the document and the court finds that the defendant has a good defense, the court will grant him leave. Now, where the court finds that the defendant does not have a good defense, summary judgment will be entered in favor of the claimant. And where the defendant has a good defense to some parts of the claim and does not have to some other parts, the court will grant him leave to defend the part that he has a good defense to, and summary judgment will be entered against him on those parts that he has no good defense. Also, where there are several defendants and any of them has a good defense, the court will grant that one leave to defend, and the judge will now enter judgment against those who do not have a good defense. These are salient points to be noted for our residual knowledge. They are most often than not exam areas. But for our residual knowledge, and because we don't really know how law school can come because they are unpredictable, so it is also worthwhile that we'll be sinking that knowledge in our head, both for the purpose of knowing it and for the purpose of being ready in case we don't know where the spear is coming from through the dark. Now let us look at summary judgment under the undefended list procedure. We said earlier that this one is obtainable in Abuja. Remember that for the purpose of our discourse in Nigerian law school, they are only using 2 jurisdictions to teach us. They are using Abuja and Lagos to teach us with respect to civil matters. So the undefended list procedure is obtained in order 35 of the Abuja High Court rules. Now, unlike summary judgment under order 13, this type only applies to recovery of debt or liquidated money demand. So anything that has to do with liquidated money demand, that is where this one comes in. Please, what is liquidated money demand? It is an amount of money that is ascertainable. An amount of money that is ascertainable. For instance, now I am owing you 50,000 naira. The name of the amount is called. That is liquidated money demand. But assuming now I finish working for you, or when I wanted to work for you, you told me just go and work, I will give you something later. It is not liquidated money demand. But assuming before I started working for you, we agreed, Oga, you will pay me 50,000. Oga said, no problem, go and work. That is an ascertainable amount of money. So we need to note that when we say that an amount is liquidated, it means that it is ascertainable. It can be counted. It is known. Unliquidated is the one that is what? Not known or not ascertainable. Now, as the name sounds, the undefended list is in itself a procedure. It is in itself a procedure, and you need to note the procedure. Please, the procedure for the undefended list is also an exam area, so it is worthy of note that we listen very well, as what is obtained in the undefended list are as follows. The procedure for bringing this application is as follows. 1. At the time that the claimant is filing his writ of summons, supported by an affidavit stating that the ground for which he claims is based, and stating that the deponent believes that there is no good defense to the judge in chambers. Please, the application for summary judgment will be filed to the judge in chambers. Unlike the order 13, order 13 is filed at the High Court registry, but in undefended list is filed it's filed to the judge in chambers. Please, I want you to also be noting these peculiarities, because these are also the differences between the order 13 and the undefended list. The difference between them is also an exam area. Law school could ask you to give them 2 similarities and 2 differences between order 13 and the undefended list. So you need to be noting. We are still going to expressly state it in the long run, sure. So when the application for summary judgment, under the undefended list has been filed to the judge in chambers, the judge shall enter the matter in a book known as the undefended list. The judge shall enter the matter in a book known as the undefended list, and then he is going to endorse on the writ the word undefended list. He will endorse the word undefended list on the writ, and a return date shall be stated on the writ for service on the defendant together with the affidavit. Please, what this means is that once you have filed this to the judge in chambers, the judge is going to enter that matter in a book called the undefended list. After doing that, he's now going to make an endorsement, that is mark. He will mark on it the undefended list and shall state that the defendant be served with those processes you have filed. Now, if the defendant is served with a writ and he intends to defend, he shall within 5 days to the day of hearing file a notice of intention to defend. Please, what this means is that unlike as obtained in the issue of order 13, the defendant shall enter his, if it's in order 13, the defendant shall enter his defense in accordance with the number of days that somebody has to enter defense in Lagos, which is 42 days. But if it were to be under the undefended list procedure, assuming that 20th of this month has been fixed for the hearing of this matter that is coming under the undefended list, it is expected of the defendant to within 5 days to the 20 days, to within 5 days to the 20th of this month, which is 15th of this month, is expected to file what is known as notice of intention to defend. Notice of intention to defend. And that notice of intention to defend is when he will be communicating to the court that, my lord, I am willing to defend this particular suit. Please, he has not yet filed statement of defense. If it is in the undefended list, he will file statement of defense. So if it's in the order 13, he will be filing statement of defense. But here, what he's filing is notice of intention to defend within 5 days to the return date. Return date is the date of hearing. Now, where the defendant fails to file this notice of intention to defend, any judgment given against the defendant will be treated as a judgment on the merits, which is the summary judgment. And I told that summary judgment can only be set aside on appeal. It can only be set aside on appeal. Now, where the defendant files his notice of intention to defend and the judge sees that he has a good defense, the suit shall be removed from the undefended list, and it shall be entered in the general cause list of the court, and the court may order for him to file his pleadings. Filing his pleading now is filing his statement of what? Defense. Statement of defense, statement of claim, all those are known as pleadings. When we go to this topic on pleadings, we will exhaustively discuss that. So the court will now order that he file his pleading and all the necessary documents, and the matter shall be officially set down for hearing. So by way of summary, the procedure for summary judgment is: 1, the defendant shall file the application accompanied by other documents to the judge in chambers. 2, the judge will now enter the matter in a book known as the undefended list and shall make an endorsement on the writ and cause it to be served on the defendant. 3, the defendant has within 5 days to the return date, that is the date of hearing, to file what is known as notice of intention to defend. 4, where the defendant does not file the notice of intention to defend, judgment shall be given against him, and that judgment shall be on the merits, which can only be set aside on appeal. 5, where the defendant files his notice of intention to defend and the court notices that he has a good defense, the court shall remove that matter from the undefended list that it was entered earlier and shall enter it in the general cause list of the court, and now order the defendant to file his pleadings. Pleadings are like statement of claim. File it, and the matter shall now be set down for hearing. Another very important exam area are the documents to accompany application for summary judgment under the undefended list. We only have 2 documents. 1 is writ of summons, and 2 is affidavit in support of the application. These are just the 2 documents. So you now see now that the documents in the application for summary judgment under order 13 are about 5 or 6, while the documents for the application of summary judgment under the undefended list are just 2. Please note these documents both for the order 13 and the undefended list for your exams. Remember, every of our online discourse are geared towards bar finals because they are confined to the law school outcome. So as this note is also playing the role of a reminder for you in the class, it is also geared to also keep you abreast and ready for the battle that lay ahead. Now let us look at the difference between order 13 and the undefended. Let us look at the differences between order 13 and the undefended list. Now order 13 applies to all claims. Order 13 applies to all claims, while the undefended list applies only to recovery of liquidated sum. I said it earlier. Number 2, application for summary judgment under order 13 is by motion on notice, supported by affidavit and written address, while in the undefended list it is only the affidavit accompanying the writ of summons. So there is no written address in the undefended list. It's only affidavit and the writ of summons. But if it were to be in the order 13, there will be motion, there will be affidavit, and there will also be written address in accompanying with other of the document that we have earlier listed. Also, the time for filing defense for order 13 is within 42 days. It's within 42 days. Remember, I believe you have been taught by now that filing statement of defense in Lagos is 42 days and filing statement of defense in Abuja is 21 days. So that time of filing statement of defense in Lagos still subsists for this summary judgment procedure that we are discussing for. But we say now that when it is under order 30, which I have said earlier that it applies in Lagos, then it is within 42 days. But when it is With respect to the undefended list, it is within 5 days to the return date. So within 5 days now, what the young man is going to be filing is not statement of defense yet. What is going to be filing is known as notice of intention to defend. But the other man is to file statement of defense. Remember, I told you that when he files notice of intention to defend within 5 days to the return date, the court shall now order him to now file his statement of defense. Please let us note that. Now, number 4 is that application for summary judgment is made at the court registry, while application for undefended list is made to the judge in chambers. So that is also worthy of being noted. Now let us look at the similarities between Order 13 and the undefended list. One of the similarities is that they both apply to cases where the defendant has no good defense. Please, this is paramount. This is paramount. This is paramount. Where the defendant has no good defense, that is the only basis upon which the court will be considering that summary judgment. But remember, I told you that you came and filed it in court does not mean that the court will give you judgment. No, there are still procedures, and you now see from what we have discussed, both in Order 13 and undefended list, there is always a place for the defendant to be served, and the defendant will now be given a chance to play his own part. Then the court will now use the part that has been played by the defendant to form its judicial opinion. Also, the number 2 similarity is that they are both applications where judgment is to be gotten expeditiously. I told you very, very well before, and I'm repeating it again. You could see in a scenario where law school could, after giving you a set of facts, they could tell you maybe in question number 1A, assuming the claimant wishes for this matter to be determined expeditiously, advise him on the mode he is going to employ. Just say that he is going to bring the matter under the summary judgment procedure. When you answer that, you have gotten your 2 or 3 marks. So it is worthy of being noted. This topic we are discussing today is an exam area, and I told you how questions could be coming out from them. Now, during our extension classes, we are also going to be looking more in depth, maybe with past questions, on how questions can come and also how to tackle them. Now, the number 3 similarity are that they are both supported by affidavits. They are both supported by affidavit. Number 4 similarity is that they are both commenced by a writ of summons. Remember, when you were taught about the mode of commencement of action, you were taught about 4 modes. You were taught about petition, originating summons, originating motion, and writ of summons. So summary judgment is commenced by way of writ of summons. You could see a problematic scenario where they will tell you that the young man commenced the action by way of originating motion, and he is asking the court for summary judgment. Please, it is wrong. He has to commence it by way of writ of summons, because law school may ask you to comment on the propriety or otherwise of the mode by which this application for summary judgment has been commenced. Please, the mode was improper because it ought to have been commenced by writ of summons. Also, the next similarity is that both applications are to be brought at the time of commencing the action. If you notice, all the applications are brought at the time of commencing the action. The time I treated with you the topic on interlocutory application, I told you that there are some applications that can come to court at the time of commencing the action, and I told you that some such applications are, for instance, summary judgment. If you notice now, application for it is made when you are filing the writ of summons, and writ of summons itself is a mode of commencing an action in the court. So if I am bringing an application when I am also filing the particular mode of commencing the action, the implication is that that application is also filed when I am instituting the action. Also, another similarity is that both of the judgments are final and can only be set aside on appeal. I told you that judgments that are given under the summary judgment procedure are final and cannot be set aside by the same court that gave it, except on appeal. Now, let us look at the brother of summary judgment, which is known as default judgment. Default judgment. Please, if you notice, summary judgment is brought at the time when you are instituting this action. I want you to note that, because we are going to use that to differentiate between it and the default judgment. Now, a default judgment is a type of judgment that is given when there is a default from the defendant, and this default can be either default of appearance or default of pleadings. When the defendant refuses to enter what is called memorandum of appearance, then he will be said to have defaulted in appearance. Now, when he also refused to file his statement of defense, he will be said to be in default of defense. Now, statement of defense is also known as pleading. So you can call it default of defense, or you can call it default of pleadings. Now, one thing monumental about summary judgment, about default judgment, is that the same court that gave the judgment can actually set it aside. That is what makes it paramountly different from summary judgment. Now let us discuss a little about this issue of default of appearance and default of defense. For instance, when I have already filed my writ of summons and all the necessary documents in court, and the defendant has been served, it's expected of the defendant to file a document known as memorandum of appearance. That memorandum of appearance is a way by which he will be registering his appearance in the matter before the court. Now, when the time that is reserved for his memorandum of appearance has elapsed and he has not actually filed that document to enter appearance, I can come back again. But remember, it is only when the time reserved for his appearance has gone and he has not doing it. I can come back to court again and I will be asking the court, my lord, this man has refused to enter appearance. Okay, give me judgment because he is in default of appearance. Give judgment in my favor. That is default judgment. Now, when is a situation whereby the man has refused to enter his defense? For instance, you know that in Lagos you have 42 days to enter your defense, to enter your appearance. But anyway, in practice in Lagos, appearance and defense are also within that 42 days. So you have the liberty of exercising your time up until the 41st day to enter both appearance and your defense, and nothing will happen in practice. So for instance, now after the end of that 42 days and this young man has not filed anything before the court, I can come back to court and be saying, my lord, 42 days has gone and the defendant has refused to file his statement of defense, which are his pleadings. He has refused to do that. My lord, please give me judgment against him. Now remember now that application for default judgment, this man comes back to court much later after there was a default. But application for summary judgment is filed at the beginning of the at the beginning of institution of the matter. So you need to note that application for default is after the expiration of a particular period of time, when there is a default in either appearance or default in defense. But application for summary judgment is made when you are still filing your writ of summons. When you are still filing your writ of summons. So we really need to note that, because it is going to help for you to know when application for these are made. And remember, I said that judgment that is given as a default judgment can be set aside by the same court that gave that judgment. But if it were to be in summary judgment, it can only be set aside on appeal. And application for default judgment is made by way of motion on notice. It is supported by affidavit and a written address. It is supported by affidavit and a written address. Now, I want us to note the type of matters that default judgment does not apply in. Meaning, these are the type of matter that even if this man did not file his statement of defense, even if this guy did not file excuse me, even if this guy, the defendant, did not file his statement of defense or he didn't file any appearance, you can still not meet the court for the court to give judgment. Sorry, forgive me. He will still not approach the court for the court to give judgment in his favor. So the implication of this means that the court will still mandate him, even if the defendant is not here, still prove your case before we give you judgment. So in other words, prove your case in the absence of the defendant, so that we'll hear from you and know whether this case really deserves judgment to be given in your favor. Let me come again. I said that there are some certain types of matters that if you bring before the court, some default judgment cannot be given in your favor. This is because such matters require you to expressly prove them and establish them before default judgment can be given in your favor. So even if the defendant did not file a statement of defense and it is only you that is in the court, you cannot get this judgment, because if you have not proved it, the court cannot give it. So you will be expected by the court to prove your case before judgment to be given. And when that judgment to be given, it's no longer going to become default judgment because you have proved your case. But just note that default judgment does not apply in the following types of matters. 1, when it is with respect to declaration of title to property. For instance, my father died and left a land for me and my elder brother, and I am saying that I am the one who should be the rightful owner. My elder brother is saying that he's the one who should be the rightful owner, and maybe my elder brother took me to court and I failed to file my statement of defense. And my elder brother now came back to court and said, my lord, my younger brother has refused to file a statement of defense, so Oya now, give judgment in my favor. The court will tell him no, because he is expected to prove his case, to establish the case. Even if his younger brother is not there with him in court, he is still expected to prove his case and lead evidence to show that title belongs to him with respect to that land before the court can declare such a title. Now, the number 2 type of matter where default judgment shall not be given is when it is with respect to recovery of premises. This has to do with the issue of landlord and tenant. For instance, now you as a landlord, you brought your tenant to court and the tenant did not actually file a statement of defense with respect to what you have said against him. And you came now expecting the court to now grant all the fact that you have contained in your claims in the writ of summons. The court said, no, I shall not grant it. Please prove your case before I will give my judgment. Remember that default judgment, typically, there is nothing that is proven there. It's just that you came to court telling the court, my lord, this person didn't appear, give me judgment. That is just the only thing. So nothing is proved. But we are now trying to raise some specific type of matters that despite the defendant did not file any particular document before the court, yet judgment shall not be given in your favor except you have proved the matter and the court is now convinced. And we said that the number 2 is when it has to do with recovery of premises. Now the number 3 is when it has to do with matrimonial causes. Matrimonial causes. I want to divorce my wife. She has been adulterous and I really wish to discontinue this transaction called marriage. And I now filed a petition. Remember, I believe you have been taught that the mode of filing a matter with respect to matrimonial causes is a petition. And I filed a petition before the court, and my wife, now being a respondent in this matter, refuses to file any statement of defense to state her own part. I cannot come back to court and say, my lord, this woman has refused to file his own statement of defense, or I give judgment in my favor. No, the court will still require me to prove my case. And if the court is convinced, before the court will now go into the issue of dissolution or not. Also, with respect to recovery of land, there can never be default judgment. Also, with respect to election petition, there is no default judgment in election petition. Thus, when we are going to do election petition under this topic, we are going to be seeing some salient principles of law. And most often than not, since this is an election period, questions normally come out in an election petition. So we are going to treat some salient principles in election petition and we'll also be drafting an election petition. Most often than not, question comes out on how to draft election petition, but we are not going to learn that in the online class. Our drafts are all reserved for our extensive tutorial classes. So if it's in election petition, you cannot come and be telling the court, my lord, the respondent has refused to file his address back to my petition all this while. I want you to give judgment in my favor. No, the election petition tribunal will require you to prove your case. When you now prove your case and the tribunal is convinced, the tribunal can now go ahead and grant judgment in your favor. However, it is worthy of being noted that despite any matter that doesn't fall under this one that we have treated and is a type that default judgment can be given, it could be very possible that the defendant might not have filed his statement of defense due to some extenuating circumstances. And when he is out of time, he can file an application for extension of time before the court. And if the court sees merit in that application, the court can extend time for him to file his statement of defense and the matter can continue. And remember, I told you that despite the default judgment has been granted, the same court can consider some factors and they decide to set aside that default judgment. On that, we're going to be drawing the curtain, and by tomorrow our great and awesome lecturers will be doing wonderful justice to this great topic. And until we meet again, I will be telling you all good night and do have quite a blissful night rest.